And welcome to the Week 5 video lecture. This week we're going to talk about witnesses and competency. Competency has to do with the idea of not whether they are good at what they do, but has to do with the fact that it's possible a witness may not be allowed to testify because they are considered incompetent to testify. That means that there is something legally wrong with them, that the law finds that they are sufficiently inappropriate to be a witness to kick them out. I mean, they're not even allowed to testify at all. So we're going to look at some of the rules. There were first common law rules that were kind of antiquated, and you'll see them when you actually we go through these. But they were very antiquated. For instance, if you had an interest in the lawsuit, you were not allowed to be a witness. Kind of crazy, because sometimes that might be the only witness to certain situations. But that was the way it was at common law, and it had to do with the idea that I guess it must have been if you had a lawsuit back then, you lied as necessary in your own case. It was sort of well known, and so the common law rule had to come up with that idea that if you have any interest in this lawsuit, we can't believe anything you say. Not true now, although we know that there's still that possibility. We at least allow them to testify, and then we can chop them into pieces later on, I guess. Anyway, that's just one good example. We'll see others. Now we're going to look at what the rules are, the modern rules, in both the federal rules of evidence and in states, to see that they have been modified significantly. However, there's still a few rules around in some of the states that haven't really changed them about when you're in a will contest or in a probate matter where you're trying to get something out of an estate as, let's say, an heir. In some states, you're still not allowed to testify as an heir, or as anyone, if you're going to take anything from the estate as part of whatever lawsuit is involved. But the most important one right now is what we call personal knowledge of the witness. If a witness cannot testify to their own knowledge, that means things they have seen, things they have heard themselves, they are not allowed to testify. They don't, unless they're an expert witness, which is a different kind of witness. They can't testify. You can't come up and testify, well, I know that such and such happened because John Smith told me so. No, you're not going to be allowed to testify if you cannot show you have personal knowledge. So it's actually a fundamental fact when you're examining a witness to make sure that you examine them in such a way where it becomes obvious that they actually witnessed something rather than heard someone say that such and such happened. We're also going to talk about oath or affirmation. That means when you are a witness, you actually cannot testify at all if you cannot take an oath or an affirmation to tell the truth. You might wonder, well, what happens if I just decide I'm not going to take an oath or affirmation? Maybe I don't have to testify if I don't want to. Well, you'll be held in contempt of court. You'll be put in jail until you do. So that really doesn't work. But it is a requirement. You cannot testify. You cannot be considered competent to testify unless you know that if you lie under oath, you're going to go to jail for a long time for perjury. And that's important because we do want witnesses to know that. And frankly, if we didn't have that requirement, then people could lie with impunity. And if we found out later that they lied, so what? We couldn't do anything to them. So that's why we have the oath and affirmation requirement. And then we'll also find out that judges or jurors in a particular case, judges in the case itself as it's going on, or jurors in the case as it's going on, cannot testify. They're simply incompetent for good reason. They have a real problem with either having too much believability or maybe none. But we just exclude them. It would be a difficult situation. Let's say if somebody did something while the trial was going on, and jurors could not testify. Let's say someone comes in the jury room and tries to dissuade the jury against going with a guilty. In that trial itself, they could not testify to that. However, what they could do is they could bring another proceeding where someone is prosecuted for jury tampering, and then we could bring them in there, but not in the actual case where they are jurors. All right, so let's get on to what we're going to get into here. So competence means legally qualified to testify. It does not mean that someone is in fact incompetent in terms of being mentally incompetent or that sort of thing. It just means that they cannot meet the legal qualification to testify. And nowadays, we're going to see that very few people fit this description, even people who are mentally ill. All right, so let's look at the old common law rules. People who were found to be incompetent at common law, and no longer, but at common law, were first minors, people who are less than 18. The reason why is because they could be easily influenced. They had problems with perception and retention of memory. Maybe they don't understand the importance of their testimony or the need to tell the truth, or the fact that they could be put in jail, for instance, for lying under oath. They just simply were considered incompetent for that reason. So you couldn't get a kid to testify at common law. Felons, they were not allowed to testify, and had, of course, to do with credibility problems. If you were a convicted felon, you sort of thumb your nose at the society's very large laws, the big ones, because you're a felon, and therefore you certainly don't think, at least we don't think you take the rule about telling the truth under penalty of perjury very seriously, because you've already been convicted of, equally heinous crimes. All right, people who are interested in the outcome of the case are incompetent to testify at common law. This is the one that just really, I don't know. I guess there must have been a very practical reason for it. Maybe in different times, you were considered to be, crazy if you didn't testify as necessary, no matter what, whether it had to do with the truth or not, to make sure your case came out the way you wanted it to. Nowadays, people at least think twice about doing something like that. Do take the oath seriously. Do know that we can, in fact, detect lies and prosecute them for lies. It does happen. And so there's a little bit of fear in there. So we don't have to have that rule any longer. Although there's a vestige of that still around in some of the southern states. We'll see that here in a minute. All right, atheists, if you are an atheist, you're not allowed to testify. The reason why is because you could not take an oath to, in essence, you could not bring upon yourself the wrath of God from your oath to strike you dead, basically, if you were to lie. And if you can't do that, you can't testify. This, again, was a kind of a crazy rule because atheists are quite likely or just as much possible to tell the truth as anybody else. But that was a common law rule. It had a lot to do with the fact that people didn't trust people who didn't believe in God in any way. All right, so mentally ill people were another one. If you're mentally ill, that was it. We don't let you testify at all. It may be all you have to do is put somebody up on the stand, ask them who's the president of the United States, and they say Woodrow Wilson, and then they say, okay, you know what, you're incompetent. Go away, that kind of thing. So these are kind of antiquated rules, as you can see. They don't make any sense now. Minors can testify, by the way. Now, yes, we have credibility problems, but that doesn't mean they can't testify, or that the jury wouldn't necessarily believe them. Felons the same way. People who are interested in the outcome of a case has the same issue. They can tell the truth. They can also lie. We know that, but at least we can hear what they have to say. And in some cases, they may be the only people who can testify. Atheists. Well, we kind of got past all that because we don't require people any longer to take an oath to God to have them strike them dead if they were to lie, and therefore atheists are just as good as anybody else. And we even know that mentally ill people can tell the truth, at least to some extent, and so we let them testify knowing that they are mentally ill, and we take that in consideration. All right, so the Federal Rule 601, everybody is competent unless there is a rule that says otherwise. It's like the old rule that I've asked you to ingrain into your thinking forever, and that is that all relevant evidence is admissible unless there is a rule that says otherwise. Well, this is the same thing. Everybody's competent. Every human being is competent unless there's a rule that says otherwise. The only two exceptions are the trial judge in the case at issue, meaning the trial judge in the actual case itself, or the trial jurors in the case itself. The reason why, of course, is that you would have to judge your own credibility, and that's just something we can't have. We have to have it objective. You're no longer objective, and therefore you can't be allowed to do this, because if you do, you're going to ruin the trial. It makes the fundamental aspects of the trial destroyed. So we can't destroy the fundamental aspects. Now this will happen every once in a while where something goes on in the courtroom that no one else notices but perhaps the judge or maybe one of the jurors. And you'd like to have him testify as to what the defendant just did. Maybe he gave a swipe under the neck to the witness, and only one person saw it, and that was one of the trial jurors. Well, can't do it. Sorry, you've lost the evidence. And the reason why is because otherwise we're going to corrupt the very trial process that we're going through, and we can't have that. So that's all you need to know. It's simply a rule, and those are the reasons for it, but you just need to remember it as a rule. But remember, it's also the trial judge in the case at issue, not a future case. Let me give you an example. I actually had a case where I had a wiretap case against one of the big, very, very violent drug dealing groups. And of course, when the informant in the case got on the stand and testified, We suspected this was going to happen, that two of the conspirators in the case that were not charged in that particular case sat in the back of the audience and did a little swipe under the neck as he was testifying. And we had two police officers in plainclothes in the back of the audience watching this all happen because we just knew it was going to happen. And sure enough, it did. But the trial judge also noticed it, also saw it. In fact, interestingly, the trial judge had previously been a public defender, and two of the people who did it in the class in the courtroom were his previous clients as public defender, and he knew them very well. And then explained to the jury what had happened and what actually had happened in the case, and told them, I just, if you wonder why this witness is acting kind of funny here, and his answers are kind of, very short, and he's kind of, getting down in his seat. Two people just gave him a death sign in the back of the audience. He should probably not have done that, but he did, and nobody objected. So it was something that he wanted the jury to know why this person on the witness stand was acting so funny. It was not necessarily because he was telling a lie. It was because someone was telling him that they're going to kill him. Anyway, okay, so that's a good example. I haven't seen a case yet where a juror had ever witnessed something. I've seen where the clerk of the court witnessed something in the middle of a trial. We had her testify. There was nothing that prevented that because she's not an integral part of the case in terms of having an objective viewpoint of anything. All right, in diversity cases, the state law of the competency is used in federal court. So remember what diversity cases are, and that's where we have a case that is typically under state law, but because the parties are from different states, and because the controversy is $75,000 or more, you're allowed to go to federal court to hear the case. But it's truly a state case being held in federal court. So they call them diversity jurisdiction cases. So in essence, you can get into federal court on your state case if you have people from different states on both sides of the action. So in that case, in the cases of diversity, then the federal courts will apply the state law of competency and not the federal rules. That's because they're trying a state case and they want to try it under state law. And so that the rules of evidence for the state case get used in federal court because of that. All right, remember, diversity jurisdiction is the federal subject matter jurisdiction based on litigants being citizens of different states from each other. So always remember that when we talk about diversity cases. All right, let's look at the modern rules of competency. California Rules 700 to 702, all people irrespective of age are qualified as a witness except those incapable of expressing themselves so as to be understood either directly or through a translator, those who are incapable of understanding the duty to tell the truth. That means incapable, not unwilling to say that they're going to tell the truth, but simply incapable of understanding it. This must be somebody that is either so young or so deluded that they don't even know what they're doing, and therefore they would not be able to understand that there is a duty to tell the truth. And those people have no personal knowledge of the matter at hand. So you can see here that we added a few more things here, but I'll say this too. In the federal system, this would also be true, meaning those who are incapable of expressing themselves can't testify because we can't understand them. If they're not capable of understanding the duty to tell the truth, then they can't take an oath or an affirmation, which is a requirement even under federal law. So these are really pretty much the same, federal and state. They just put these out into words, whereas the federal does not. All right, requirement of personal knowledge. That means the witness must have perceived that which they testify through one or more of their five senses. They must have seen it, heard it, felt it, whatever. And so what's important about this is paralegals are responsible for fully interrogating witnesses on the basis of their personal knowledge about their statements. So, for instance, you go out to the scene of an auto accident. You happen to be out there while things are still being mopped up. You talk to some people and you ask them, what happened here? And they say, oh, this car, ran into that car, and he didn't stop for the red light and that sort of thing. Well, if you simply say, oh, well, then you're a great witness. I'm going to write your name down. You're going to come in and testify. Well, you might be real surprised when you get to the witness stand, or your witness gets to the witness stand in the middle of the trial, and you find out that they don't have personal knowledge. What happens is they were there, but they didn't see the accident. They just came walking by after the accident happened, and someone told them what happened. And that's how they knew what happened, and that's why they told you what happened. Well, if that's the case, you've just messed yourself up real good and your supervising attorney, because they thought they had personal knowledge when in fact they didn't. So you have to, as a paralegal, make sure you ask somebody, did you actually see this yourself? You tell me this is how the accident happened. Did you see the cars collide? Did you see what happened before the cars collided? Did you see what happened after the cars collided? That kind of stuff. And if they say, yes, I did see it, okay, then what did you see? That's what you want them to tell you, okay? Very important. Make sure that that's always the case, or you'll be doing a great disservice, and it has happened before. It's even happened with me when police don't ask the right questions, and we find that out in the middle of a trial. The problem, of course, is that there may have been a witness to the accident, but we've just missed them. We don't know who they are or where they are now, several months later when the trial happens. And we don't have time to go out and find them. So we lose the case because one faulty little thing like that. All right, so modern rules of competency. Incompetency can be possible in the following general areas. So is a person going to testify in a case that involves a person who died? Now this is true because we'll see that in some states they still hold on to this common law idea that if you are testifying in a case involving a person who died, which means you're talking about a probate case, and someone is going to possibly end up with part of the estate if they win the case, then they are not allowed to testify. It's the old rule about, if you have an interest in the case, you can't testify. That's the only vestige of that old common law rule that's still around, and it's only in a minority of states, and it's typically in the southern states. So this might still be around in some states, but it is not in California. It's not in the federal system. But do know that it does exist in some places. If you are a very young child, possibly, and the reason why is for very good reason, maybe they cannot understand the obligation to tell the truth. Not that they couldn't tell you the truth, it's that they don't understand the obligation to tell the truth, so they can't take an oath or affirmation. You get your people, 5-year-olds, 4 years old, 3-year-old, they can't do that. They basically can't do it. They can't be a witness. They can't qualify as a witness because they don't know that they're supposed to tell the truth. They don't even know really what's happening. And so we don't know what we're going to get from them. And so it's really because they can't take an oath. Not because they're young children, which is just bad enough, but it's really because they can't take that oath. Those who are mentally impaired, if they're so mentally impaired that they either cannot express what they had seen or that they can't understand their obligation to tell the truth, then they are incompetent as witnesses. If they're insane, most likely, then typically they won't be able to understand what they're doing. They can't take an oath because they don't understand the duty to tell the truth. They probably are marginal as witnesses anyway, so you probably aren't losing very much because no one will probably believe anything they had to say. And the reason why is because it's just not reliable. But the real reason, the legal reason, is because they can't understand the duty to tell the truth, so they can't take an oath or affirmation. Any hypnosis has been tried on the witness. This is actually a rule that's been instilled by the courts, not by the law. I mean, it is by the law because the courts make up the law, but it is not by a statute, for instance. But hypnosis has been known to be extremely, extremely in a situation where it can make people say things that never happen. In essence, you're very highly suggestible when you're under hypnosis. And so people might suggest to you that you know something, and so you'll make it up. And you don't realize that you've made it up, and it becomes then an actual memory in your mind that never happened. There have been a lot of studies about this, and it's quite true. You can actually do this to people, and they've done it, and you can see it on some great documentaries if you ever get a chance to watch some of these documentaries, where they talk to people and they interview people and they ask them questions, and they ask them about, some event that happened in their lives. So we know what the event is. We know what happened in that event because perhaps we have other people who were at that event in their lives, and then we ask them about that event. And then we say, do you remember the lady in the white dress? And they may say, well, I have a vague memory of this lady in the white dress. Well, what's really happening is you're making them think they should have had a memory of the lady in the white dress because you're saying that that person was there, and so they'll make up a memory of it. And they don't even realize they're doing this. So it doesn't necessarily even have to be hypnosis. If you suggest to witnesses what to say like that, you won't necessarily make them incompetent as a witness, but you'll destroy their credibility for sure. And what hypnosis does it even worse because they really don't realize when they're under hypnosis that they are creating a memory. So this is, the old situation where someone says that they, they have a repressed memory from 30 years ago, and they're now letting it out for the first time. Well, what happens is they go into hypnosis. The psychiatrist has this idea that something really bad happened to them in the past, and so they start suggesting to, isn't it true that your father raped you or something like that? And then the person will actually start to say, okay, well, I guess he must have done that. So they make up an instance where it happened, and they don't realize it's happening. This is quite true. You would not imagine this is something that people could do without understanding that they're doing it, but yes, they can. And so they'll testify to it thinking it is a true memory when it really isn't. So there's some real problems with that. All right, so look at oath or affirmation. All right, under California Rule 710, Federal Rule 603, it's required for competency that a witness take an oath or affirmation. That means they either take an oath to swear to God that they will tell the truth, which is a way of saying, strike me dead if I lie, or an affirmation that says, I swear or I affirm that I will tell the truth under penalty of perjury. So it basically just is a reminder to them that they are testifying under penalty of perjury. It's also necessary for a perjury prosecution that they be put under oath or affirmation. Otherwise, they can lie all they want, and they can do so with impunity under the law. So we have to have this to make sure that at least they know that they're going to be put in jail or prison if they're caught lying under oath. Now, it's required. Now, you think, well, wait a minute. If I just simply say I'm not going to take an oath or affirmation, can I get out of testifying? The answer is not really, because what will happen is that'll be considered a contempt of court. You'll be put in jail, and whenever you decide you're going to take the oath or affirmation, then you'll testify. And they'll hold the jury there until you decide you're going to do it, and you'll be in jail until you do. That's sort of their way of doing it. All right, so if you also use an interpreter for the witness, they must also be under oath to make a truthful translation, and that translation becomes legally what you have said, whether in fact it was what you said or not. All right, so an oath is a solemn promise to be truthful accompanied by swearing to God, which is essentially asking for, spiritual retribution if you were to lie. And then affirmation is simply a solemn promise to tell the truth. And you can do either one. And so what they typically do now in California is they say, do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God? And that's how they do it. So they, in effect, they may even take off "so help you God" kind of thing nowadays, because otherwise that would not work for the affirmation part of it. All right, judges and jurors as witnesses. Everybody is competent unless there is a rule that says otherwise. The two exceptions are the trial judge in the case at issue, or the trial jurors in the case at issue. We've already gone over that one. Just remember that rule, and we already know the reason for it is that it would corrupt the very trial that you're in. The whole process would be corrupted if you allowed that, so we simply have to not allow it, even though it may be giving away perfectly good witnesses to a certain thing that may have happened in the trial. All right, now there's also a rule, Federal Rule of Evidence 606B. Jurors may not testify to any discussions or deliberations during jury deliberation. That means we want the jurors to feel that they're free to say whatever they want, even if they say something that is very biased or prejudiced, and they say things like that. Sometimes we want people to be able to speak freely and let those things out, so that in the group we can say, okay, well, that I understand your feeling, but we got to get past that feeling and get into the facts of the case and not let that bias or prejudice influence our decision here. And we want those jurors to never worry about their deliberations coming out and being put out to the whole world to see, because if they knew that was going to happen, they won't be able to say what they need to say in the jury room, so that they can have any biases or prejudices brought out there and aired out, so to speak. Or they can also not testify to any emotions influencing the jury during deliberations. Those are, again, that's a private information that if we allowed to be put out to the world, jurors would not be able to express their emotions, and things can actually go wrong because of that. We think that if we allow people to air it out, free to never worry about it ever being brought out again, that it's much better than to make people not want to bring it out at all. So just remember, this is a rule. Any discussions or deliberations during the jury deliberation, or any emotions influencing the jury during the deliberations, it's not allowed to be testified to by any of the other jurors or anyone else, no matter what. All right. However, jurors may testify to whether prejudicial information got to the jurors, whether outside influences entered the jury deliberations, or whether there was a mistake in filling out the jury forms. Those are things they are allowed to testify to, obviously, because those are the only witnesses, and because it doesn't bring out anything that would prevent jurors from freely speaking their mind to other jurors. All right, so that's about it when it comes to competency. It's pretty easy stuff, and we want to go by, of course, the modern rule, but you do need to know what was there at common law in case there's a question about what was going on at common law. But otherwise, it's pretty easy rule. The general rule is everybody can testify unless there's a specific rule otherwise. You start out with that premise on the modern rule, and otherwise you're applying the common law just as a historical basis. And then you look for what rules there are that prevent people from testifying, and there's very few of those. So not too difficult of a chapter for this particular week. All right, again, if you have any questions, again, please feel free to give me a call.